You guys had enough of that intro? Welcome to the show. Got a special show here on the lounge. And tonight on the lounge, I'm drinking tea because, as you can tell by my voice, I am not feeling the best. But be that as it may, we got Pat King sitting in the green room. We're going to bring on Stefanos. Hey, say hi, Stefanos. Welcome to the show.
Howdy, howdy, howdy. How's it going, everybody? Should be a good one.
Yeah, and let's bring Pat King in. I'm going to try to get get our other guest in here, troubleshoot this for him. And if you want to get going with Pat King, I'm sure a lot of people haven't heard much from Pat in a while, and let's get some updates here. What's going on, Pat?
Hey guys, how are you guys this evening?
And here's our lawyer, I hope.
Oh, no camera?
Other guest in here, troubleshoot this for him. Lawyer. Well,
there we go.
There he goes. Well, there he goes. Hi, Brian. Hi, Brian.
You're not live on Facebook or anywhere.
No, we can't hear you right now.
You're not live on.
Anyways, guys, I'll work on this from behind the scenes.
There's an echo on Ed's side too as well. So
yeah, Ed, Ed never mutes the mic, so he's always echoing on us. So what's going on? Haven't heard much. I don't know what you're doing with your case there. It's being heard in Ottawa, right?
No, it's being heard in Toronto, actually.
Ontario Court of Appeals.
Ontario Court of Appeals, yeah. We, as you see, the lawyer was in here to give you a little bit of more update on most of that stuff. But from what I know, from what I've read, from what I've seen, our factum is complete. Oh, there's Brian there. Are you working? Is your volume working? Yeah, no, it's not working,
Nope.
Brian. I'm not sure. But anyways, yeah, so we are in the factum is done. It's been sent in to us, and it's done pretty maliciously. Let's just put it that way. It's pretty. There's so many holes and so many mistakes, and they're refabricating what the judge said. They're refabricating what the verdicts were. They're refabricating everything in the factum that they put through, and we're having to go through all of it and point out all the errors in their response. So we're working hard at it. Brian's doing all the work, really, but at the same time, I'm steering this ship this time. I'll be steering my case and making sure that the right things are being done and nothing is getting pulled over my eyes. It's like my trial. I'm just curious. I don't see the chat. Do you guys have it turned off or?
No, we got a chat. Look at the right side of the columns there. You'll see where it says comment styles and private chat. Go click on the comment side. Click on comments, and then you should be able to have there should be look for a little arrow. Maybe it's closed. You can hide the panel or open it.
No, I don't have that at all. All I got is you guys in the studio. Interesting.
Oh yeah, because there's comments going through. Everybody saying hi and from different places there.
That's how I usually get my start. Is I look at the chats and see what people are saying, and then I can give a little bit of a heads up. But neither here nor there.
It's going though. We got people from YouTube and from Facebook, so everybody's quite a few people there.
Okay, so as we work through this, it's another ongoing example of straight up the weaponization of this judicial system. There's no question about it. This is malicious prosecution. This is a targeted incident. They're not happy with what they got, and now they're not going after the evidence. They're going after the judge and basically saying the judge made so many mistakes in the case.
Yeah, well, these appeals are always based in errors in law, but so they're going to say the judge erred in wherever, and they're going to have to spin it any which way they can spin it to give their side the upper hand.
Well, in fact, the judge didn't err in law at all in any time through his trial, through my trial. And in fact, he allotted several days extra to make sure that there were no errors in law. And in doing so, it was, we were happy with the verdict. It is what it is, a year in jail, well, whatever. At the same time, it's leave it be. Let's leave a dead dog lie, as the saying goes for most people. But no, they didn't get enough pound of flesh out of me, so they want more. And Brian's been meticulous in this, and he asked, hey, man, can I please oversee your appeal? I think we really need to focus on specific case studies, specific instances to really take this to them. So it was kind of, I don't know, a blessing in disguise. And Brian came through the channels, through our little networks of people, and here we are. So we've finished our response to the factum at present, and now we thought we only had 30 days to respond, but it turns out by law it's 60 days to respond. So now we got even more. He rushed through it. Not that it was a rushed project, but he tried to get it done and ready to go within 30 days. But now that the rough draft is ready, we can really meticulously go through it with a fine-tooth comb, and we've got ample time now to look at our arguments and look at our case laws that we're using. Brian can go specifically on the case laws. I'm not going to bring up much of it, but I can bring up some of it.
Yeah, and once you perfect your appeal, you'll get a little bit more time there too. So to perfect it and everything. So it's just the initial and everything. So you get a little more time.
So in the appeal, the Crown is going after the intimidation acquittal. So there was 4 intimidation charges that I was given. And I say he because I know it's targeted by a specific individual. And I know this individual very well. This individual is one of the biggest monsters in the Ottawa court district. And he knows it. And I'll always say it to his face too. You're a monster. You're not a Canadian. You shouldn't be doing this to Canadian citizens. But at the same time, here we are. That being said, we've got so they want a sentencing appeal on the mischief conviction. They want issue 1 is the intimidation or acquittal to correct in law and fact, and then issue 2 is sentencing, no error in principle but proportionality. They want basically 5 more years is what they're saying. Believe it or not, they want 5 more. They figured they couldn't get 10, so they want 5. They want at least a minimum of 2 plus a day. They want this federal time, and this is to set it up for, future protests, because they do know that it's coming down. They do know that some serious things are about to happen, and unfortunately, I'm the target. I was the first one to get it. I know it's 2 other people that are going through this now at the same time, but I know that mine is the juicy one. Mine is the one that they want the most. I know that they feel that they have enough evidence in their repertoire of bullshit, and I'll say it's bullshit. Their evidence is bullshit. That they're going to they can handpick. But the one thing about this is they can't handpick an appeal. You're only allowed to use the evidence that was used in the case. You can't bring forth new evidence. So with the evidence that was brought forth, it was cherry-picked evidence, cherry-picked witnesses, cherry-picked everything. We can peel it apart like there's no tomorrow. How's that, Brian?
I'm here. Are we able to? Yes. Can you hear me?
Yes, finally.
Oh, good.
We got you.
Good.
Yeah, we got you, man.
I'll just kind of I'll let Pat. You were talking about the case.
Yeah.
And
so, ladies and gentlemen, now that we've got him here, this is my lawyer here. This is Brian Duty from Ottawa. Brian's been instrumental in a lot of the cases within the convoy charges and things such as that. He's been integral in getting charges dropped, getting charges dismissed, getting motions and orders passed within the courts. And I have full confidence in Brian that he's got the reins on this and looking very positive with our argument that we have. Yeah, go ahead, Brian.
I think we have some very strong arguments, given that the Crown has only appealed two things. They've appealed the acquittal on the intimidation charges, Section 423, subsection 1G, for blocking a highway. So they're appealing that, and they're appealing the sentence, saying that it wasn't harsh enough. So our appeal is focused on those two areas of appeal, but the facts of the case are very much work in Pat's favor. The law works in Pat's favor. The type of offense that intimidation is, the way it's written, it's called a specific intent offense. And if I can just be really quick here, I'm of the view that Pat was convicted on the mischief charge, in part because mischief is a general intent offense. But and the difference is fairly, well, it's a problem in Canadian criminal law, trying sometimes interpreting what is a general intent offense and what is a specific intent offense. But when an offense says that, there's a purpose, you have to have a purpose of intimidating someone to do something that they don't want to do. So that purpose is part of what has to be proven, and it simply wasn't proven. The judge said there's no way that you can find on these facts, given that intimidation is a specific intent offense, there was nothing on these facts that Pat King did that was specifically intended to intimidate any person, despite what the Crown says. So the Crown is trying to argue that it is an error in law, but really their arguments are, they're trying to argue that the judge erred in law, but in fact their arguments are based upon the judge erring in his interpretation of the facts. So it's an uphill battle for the Crown to overturn an acquittal, a finding of not guilty on the intimidation charge. And so we're really working hard on that. Pat said that it's finished. We're finished the argument part, and that's in part because I was trying to get it finished early. We have 60 days from the date that the factum for the appellant was filed. So that was actually the 29th of October. But there's still a lot of stuff to do. We have to get put together a printed copy and bind it and send it in, and before that service. So there's still a number of things to do. But I'm satisfied the arguments are we have the arguments done. So I'm just writing the start, the facts, which is a little bit tricky because it's not just our version of the facts. We're saying, okay, given what the Crown in their appeal has said about the facts, this is what we as the respondent feel about the facts. And in a nutshell, they're trying to dress up the judge's own interpretation of the law as an error in law, and those two things are not the same. An error in law requires, like it says, a mistake in law, but the judge applied the law as far as the intimidation charges were concerned. But the big thing is the specific intent. There was no specific intent proved at all. Specific intent might have been, for example, if Pat had said that there was some specific person that he wanted to cause,
like a targeted
person, but there was no target, and the case law is very clear on this specific intent versus not specific intent. It has to be proven. It has to be something more than just the act. So what the Crown is trying to do is saying, well, the trial judge Hacklin said he talked about blocking the road, but he said this is not a specific intent offense. And then he also talked about if we were to accept the Crown's interpretation here, you would be criminalizing large, essentially you'd be criminalizing expressive behavior. People who protest to express something. And that's not what Parliament intended when they wrote the intimidation offense at section 423. It's that purpose word there at the opening words. It says there must be a purpose. And I'll just get my criminal code out here because it's good to read it.
If I could.
So it's important. It's important. The opening words are important. So it says everyone is guilty of an indictable offense who wrongfully and without lawful authority for the purpose of compelling another person to abstain from doing anything that he or she has a lawful right to do, or to do anything that he or she has a lawful right to abstain from doing. But it's that purpose of compelling another person that simply was not proven. But the Crown in their appeal documents are trying to say that it was proven. But the case law is very clear. When you're proving, the Crown has to prove a specific intent offense. When it says for the purpose of compelling another person, that purpose of compelling another person has to be proven beyond a reasonable doubt. And that wasn't done in this case. So that's the weakness of the Crown's case, and it's the strength of Pat's case. And the other grounds for appeal is the sentence. And the Crown has to ask the court for permission to appeal the sentence, and only then can they argue on the sentence. So there's a strong threshold that has to be met. And I argue again, the Crown doesn't meet that threshold in this appeal document. Again, they're trying to dress up. They're trying to claim something that it isn't. They're trying to claim there's an error in law. They're trying to claim that the sentence is manifestly unfit. But it's all, the sentence and the acquittal were all done under the statutory authority that's in the criminal code. So that's the strength here, because our arguments are based on statute. But the Crown is we're responding vigorously to all of the arguments. But it seems that when we respond, there seems to be a pattern in the Crown's appeal arguments that like they claim it's an error in law. They claim it's manifestly unfit. But what they're really doing is they're criticizing the judge's interpretation of the facts. They're criticizing the judge's application of the law to the facts, which is within a trial judge's area of decision making. It's up to the trial judge to hear the evidence, hear the arguments, apply the law to the facts. And case law on appeals under the criminal code say that the trial judge's decision has to be given deference. So that acquittal, that not guilty finding on intimidation, has to be given deference unless there can be an error in law that is proven beyond a reasonable doubt. And with respect to the Crown, that they have not, in our view, they have not proven that. So we're confident that we have strong arguments and that we're putting strong arguments forward. And so the Court of Appeal is going to have strong arguments from us, and we'll see what happens.
Can I ask quickly?
Yes.
The original charge of mischief is what convicted Pat, correct?
Yes.
And
Well, that did not occur.
Okay, but here's the thing. There's a whole bunch of tests that have to be met for that conviction to stick, correct?
Yes, but in this case, Pat is the respondent. So in this case, it was the Crown who made the appeal. So the Crown is the appellant. And when the Crown appealed, it only appealed the not guilty finding on the intimidation charge or the charges, and it's appealing the sentence. So even though the mischief charge is not before the court in terms of we're not cross appealing it, and the Crown is not appealing it, but still it's the same facts. The trial judge Hackland said, most of the evidence here is really the evidence that convicted Pat King on the mischief charge was really based on the social media evidence, largely on the social media evidence.
So are we
None
are
of
we
the-
allowed to argue? Are we allowed to argue to have that thrown out?
Well, no, but it's still relevant. It's still relevant to our arguments that we're making on the intimidation charge. So I would say, the quick answer is mischief is considered to be a general intent offense, so that all that needs to be proven beyond a reasonable doubt is that the person committed the act of mischief. They don't have to prove that the person intended anything more. Versus the intimidation charge. With intimidation is a specific intent offense. So in order to be found guilty of intimidation, there has to be proven beyond a reasonable doubt that there was a purpose of compelling another person to do something that they didn't want to do. So I think it's really it's connected to the mischief in the sense that it's the same evidence, but the law on intimidation is different from the law on mischief. Again, I don't agree with the court's interpretation of mischief. I think they didn't take into account a lot of factors, such as there was the municipal injunction, which is a big deal in municipal law, and nobody seems to want to acknowledge that. So those are factors that are relevant, but I think ultimately it would be different if we were cross appealing the mischief, which we're not doing. Then we would make different arguments there. But it's ultimately,
are we able to cross appeal?
Well, at this stage, I don't think. I think it would be very complicated to do. I'm not saying it couldn't be done, but I think by focusing on what's under appeal, by focusing on the fact that the Crown is appealing the not guilty finding on intimidation, and we focus on that, it's the same evidence. What the Crown is trying to say is the same evidence that was used to convict Pat on the mischief charge is sufficient to convict Pat on the intimidation charge. And our argument as respondents is that it's not sufficient because it doesn't have that specific intent, that purpose of trying to cause some person to do something that they don't want to do. And that was not proven beyond a reasonable doubt.
So I got a question here, and if I don't know if Pat said this correctly or not, but from what Pat said earlier, they're trying to make this now a federal charge. So was it on a summary conviction at the beginning, and now they're asking for an indictable offense?
No, these were the Crown on these charges for Pat King's trial. They elected to proceed by indictment, and the trial was before a judge of the Superior Court of Justice, and it was Justice Hackland, and so we were in the Superior Court. And
so the jurisdiction is not there. It should have been in a federal court instead of a provincial court per se.
Well, under the Constitution, the Superior Court of Justice is the Superior Court for criminal matters. If the Crown had elected to proceed by summary conviction, the matter could have been heard in the Ontario Court of Justice. By comparison, the trial with the other long mischief trial with
Barber?
Leach and Barber. Thank you. Now that was interesting, and this is where criminal procedure kind of gets interesting, and it's been modified a bit. It was modified a bit in 2019, and I don't want to get into too much detail, but the bottom line is Barber and Leach, their counsel, their lawyers, elected to be tried by a provincial court judge by indictment. So they're proceeding under the indictment, but the judge in Barber and Leach is a provincial court judge. I know I don't want to get too confused. It's this whole thing about elections. So you can elect, if you're charged with mischief, you can elect to proceed by summary conviction. You can elect to proceed by indictment. You can elect to proceed by indictment before a judge of the Superior Court. And you can do like in Barber and Leach, they elected to proceed by indictment before a judge of the provincial court. I know it's confusing. It's confusing for lawyers as well. But in the case,
I get it. I don't know if our audience gets it, but then our my next thing was, what about the Courts of Justice Act 137.1? Would that not apply in this to have the proceeding dismissed because of the fact that this is proceedings clearly put against Pat and others, I'm going to say in general, of limiting debates. This is clearly was an issue that's of the public interest, and I'm thinking that this was done in order to silence people and make examples out of them, instead of letting the public interest and the debates continue.
Yes, well, I've argued, one of the arguments I've made, I made it in the Ontario Court of Justice and for the other clients that I represented, and I'm making it in Pat King's factum as well, is that a lot of people, there was that Lexi Lee injunction on February 7th, 2022, and I think the Crown and the judges have all focused on that. And for some reason or another, very few legal counsel, maybe none except me, but I don't want to say I'm the only one, but nobody raised the issue of the municipal injunction. Now, before I was a lawyer, I was teaching, municipal governance and provincial governance and federal and provincial, how they have to cooperate and how they have their own jurisdictions. And I don't know, you remember it was the last week. It was 1 week before the arrests on the 18th. The province of Ontario declared a state of emergency. Mm-hmm. And I look at some of the media coverage, and there wasn't, people were saying this doesn't really mean much, and then pictures of the premier, it didn't seem to be very much analysis of it, because the declaration of emergency came on a Friday afternoon, February 11th, 2022. The actual regulation under the emergency was issued on Saturday, February 12th, 2022. So unless you know where to look, you really weren't going to be able to find it. And I was of the view that even the police and even Amiot, the city manager, didn't seem to be aware of the significance. But
Kim Ayotte,
yeah. But it's the combination. So it's the reading together. So that the municipal injunction is a big deal. It's like it's the judge of the court saying, municipal government police are obliged to enforce these bylaws. And the most insignificant bylaw is the bylaw to keep streets clear. Cities, under the Canadian Constitution since 1867, under Section 92, subsection 8 of the Constitution Act 1867, the cities, and in the case law, the Confederation case law, each province sets the rules for municipalities. There are different rules in Quebec, different rules in Ontario, but in Ontario, the rule is the cities are the owners of the streets. And as the owners of the streets, they have an obligation to keep the streets free of obstructions. Now, the problem was the city was saying, well, we can't really enforce the bylaws, but it was the emergency regulation that gave the police extraordinary powers that they didn't have before. So it was the combination of the municipal injunction ordering the police to enforce bylaws, and the police, all municipal police forces in Ontario have an obligation to enforce municipal bylaws. That's part of their statutory authority, comes from that. But what the emergency regulation of the province did, it gave the police the power to seize driver's licenses. Now, police, there's case law, there's the Highway Traffic Act. When the police approach a motor vehicle on a highway or a street, they can ask for and are entitled to receive the driver's license of the owner operator of the vehicle. But in this, so the powers that were given to the police, they were given the power to take the driver's license, and then they could order the owner or operator to drive away and not come back. So that's what's called a...
Not only did they do that, though, they also had the ability to revoke your insurance as well.
Yes.
And they did that because they revoked my insurance.
They did.
And my driver's license.
Did they? Because the revoking of the driver's license is not something that can be done remotely. It's really something. I mean, here's the other problem I have with the way that the police managed all this. You know, the police kept saying that they were giving people notices, but they weren't going. They weren't going directly car to car, truck to truck, and talking to the actual owners and operators of the truck. But that's what the Highway Traffic Act empowers them to do. The emergency regulation referred directly to the powers in the Highway Traffic Act, and it referred express.
Oh, Brian froze. Stefanos, we're just getting quoted the Municipal Act bylaws. I thought bylaws only apply to employees of the city corporation.
No, Ed, bylaws are going to apply to public. So the streets and everything is public. So that's going to be all under the government. So municipalities are creatures of the province, and they have to follow what the province tells them. This is why, as a lawyer here was saying about the declaration, the emergency and stuff. Now, that what the municipality had done, and this was one of the things I wanted to ask him, is was it unconstitutional what they done? And if it was, the Municipal Act strictly forbids them from doing unconstitutional things, making bylaws or these declarations. Under Section 14.1 of the Municipal Act, it strictly forbids them from interfering with things like, interfering with provincial or federal legislation or the Constitution. Okay, Brian's back, so that's good.
Sorry. I'm having so many technical problems tonight.
No worries.
Okay, we'll get through it.
So one of the things I was just saying, Brian, I don't know if you heard it or not, but that declaration, the municipality, and this is one of the things I always harp on, because I'm with the Ontario Landowners Association. We push back from government overreach. So we've sat as interveners on Supreme Court of Canada cases such as the Annapolis case, the Lynch case. We're recognized as private property experts and all that kind of stuff. But one of the things we always look to in the municipal acts would be Section 14.1 of the Municipal Act, where a municipality can't create bylaws or interfere with provincial or federal legislation. So would that declaration that they made, would that not be interfering with the Constitution? So would that, and you're saying that, you're surprised nobody's looked at it. I'm surprised nobody looked at it. I'm even more surprised that nobody challenged this constitutionally, and even in the Courts of Justice Act at 137.1. So this is what I've been shocked at, and all of the cases that nobody done any of that. So I don't know, what's your take on the 14.1 on the municipality not being able to interfere with provincial or federal or the Constitution?
Well, I know in terms of the Municipality Act at section 440 allows a municipality to go to court and get an injunction to have its bylaws enforced. So the fact that the city had to go to the court and get an injunction on February 14th, 2022 says a lot, I think, about some of the problems that they were having. But the combination of the municipal injunction plus the emergency police powers, in my view, and I've argued this, it created a civil remedy that was an alternative to criminal charges. And the city, in my view, and the police as agents of the city had an obligation to enforce those civil remedies, but they never did. They went right to the criminal remedies. And but
was that injunction even constitutional to begin with, though?
Well, I would argue yes, it was. I think part of the problem was that on February 14th, 2022, the federal government declared its state of emergency, public order emergency.
Which was
and I think there
overturned.
was yes, I think there was some confusion about, I think that the police, there may have been some confusion about what was in that declaration of emergency. You know that in January of 2024, the federal court, Justice Richard Mosley, in a lengthy decision, declared that it was unconstitutional, ultra vires. But I think the most important observation he made was that, in the Emergencies Act, at section 17, that's the section where, when you're declaring a public order emergency, you have to declare, is the emergency in a specific area of Canada? You have to state the area of Canada. If it's not in a specific area of Canada, then it applies all across Canada. And what the cabinet did is they made the emergency apply all across Canada. It was not locally tailored. But the Emergency Act itself was designed so that the public order emergency would be locally tailored. But there was no, the declaration of emergency didn't say that the emergency is in downtown Ottawa, or it's on Wellington Street and up to Rideau Street, or they didn't name any streets. They didn't name any areas of Ottawa or Coutts, Alberta, or Windsor, Ontario. They didn't name any area.
Not only that, when they filed the Emergencies Act, they also filed the Emergencies Act on a Friday, gave the Senate the day off so that they didn't vote on it. Then when the Emergency Act was enacted without the Senate even agreeing on it, it went for the weekend, and then on Monday when the Senate was back, they revoked the Emergencies Act. There's several things that took place in this Emergencies Act that was very nefarious.
Well, I think part of the confusion, I think part of the confusion was that the provincial declaration of emergency was on Friday, February 11th. The provincial regulation came out Saturday the 12th. On Monday the 14th, the municipal injunction came out. And I know you may recall that the federal cabinet met on Sunday the 13th, and they came out with their declaration of emergency on the 14th, and the actual emergency regulations were not published until Tuesday the 15th. But I think part of the problem was there was some confusion. I think there was the confusion on Parliament Hill, I think, was that the people on Parliament Hill weren't even I think, aware that there was a municipal injunction on the same day. And I think this is part of because the courts were not fully open at that time. So even for a lawyer to get into the courthouse was, you had to ask for permission to say that you
Right.
had to be there for a valid reason, So I think there was some confusion. I think the municipal injunction is helpful because in it the judge who made the municipal injunction is presumed to know about the provincial emergency powers. So police had the power to seize driver's licenses on the spot under that provincial regulation. And part of ordering individual owners and operators of vehicles to leave is done on a one vehicle at a time basis. And the police just simply didn't do that. They simply went right to the criminal remedies when there was a very, very, very real civil alternative that would not have resulted in criminal charges and would have, if it had been applied, in my view, it would have removed the vehicles from the downtown, but they wouldn't have had to be towed away. The vehicles would have been driven away by their owners and operators. And I think that was the intent. That was the intent of the municipal injunction plus the regulation. But it was just forgotten. It seemed that all the attention was based on the Emergencies Act. So an ordinary person reading the Emergencies Act would presume that the area of downtown Ottawa was named or expressly mentioned in the declaration of emergency, but Justice Richard Mosley of the federal court found that it wasn't, and this was one of the reasons he found the declaration of emergency to be unconstitutional and ultra virus, is that it didn't have any local remedies. It just had this. It said there's a public order emergency. It's not limited to any particular area of Canada. It's all across Canada. And I think they did that in part because they had other objectives. They had the seizing of bank accounts, and that was done across Canada. So that wasn't a locally tailored remedy. So the problem with the Emergencies Act Public Order Emergency Declaration was that it didn't follow the Act. The Act says you can do either. You can say at Section 17, okay, is the public order emergency? Is it within a specified area? Okay, say the specified area. But if you don't say the specified area, then it's the public order emergency is all across Canada. And I think that was the problem with the declaration of the federal emergency, is that they made the emergency all across Canada, and it really didn't provide any local enforcement tools. And I think, it was problematic from the beginning. And I think it drew all the attention away from this municipal provincial remedy. Call it a civil remedy.
The Ontario provincial government filed an emergency declaration.
Yes.
The Ottawa City filed an emergency declaration, and in fact, what happened was right after the conviction of myself, there was an article put out in the National Post, and in that article, it said this is unsurmountable proof that the Emergencies Act was not needed because there were things in the toolbox that could have used without having to file the Emergencies Act.
Yes.
In fact, my case can prove that I was charged under the criminal code and that the Emergencies Act was null and void. There's several instances where this was, you can see that this was a tactic that was used. I think what they saw was they needed to end it. They needed to end it now. So they were going to just, who cares? We're just going to do this, and then by Monday, when it's all cleared out, we'll pull it back, and we won't be in any trouble for it. And I think that's what we saw. I think we saw the federal government make a major mistake, and now they're trying to silence us, or silence myself, or silence many of us from even bringing this information forward, because the more that they keep us wrapped up in the courts, the more that they limit our exposure on this. But I think, Brian, this thing needs to be public. I think the appeal in itself should be a public right to know what's going on by televising this. Same as my trial. If my trial was televised, this whole fiasco would have been over. The Crown Attorney's Office, malicious prosecution, direct targeting to a specific citizen, The charges that I was charged under, which were actually dropped and acquitted, shows that they were just trying to throw anything they could at us, at myself, at any protester that was in Ottawa. They were throwing whatever they could to stick at anybody to get us out of there silenced and quieted. I think this needs to be public. I think this needs to go international, what they're doing here in Canada. I truly hope that we can make this a public spectacle.
Yeah, and the problem with that, Pat, is they went and made it so at a criminal, you can't watch through Zoom anymore on criminal cases. So
It's
they
not Zoom. I'm talking like on TV, like CNN does, like they do with Amber Heard and Johnny Depp cases, like the fiasco that you see in the United States and how they televise all their stuff.
They won't let you do that here, but I'm just saying, at least if
in fact they can. In fact, they will. They have to when you put a motion in. We put a motion in for my trial to be shown to the public, and in fact, Justice Hackland, his excuse was, I don't want my courtroom to be turned into a circus. So no.
Right. And
how is it going to be a circus if you have cameras in there watching it? The courtroom isn't going to be a circus.
Right. You're on camera in there anyways. Yeah, exactly. And then the other thing is, there was, if I remember correctly, there was an order, I think it was to do with the honking. And there was an order that was put in, an injunction, that between a certain time and a certain time. But at the end of that, or in that injunction, the judge actually declared it a constitutional protest. It was a legal protest. So this is what astounds me, that they come up with an emergency when, this was never violent. There was no violence. There was nothing like that. It was always peaceful. So it was constitutional. It was even declared that. And then I believe it was, and I don't know if this was one of the emergencies that the province declared with Doug Ford, but they came up with Bill 100. I think that's unconstitutional beyond belief. But in that bill is where they could seize your car, your license, all that stuff. And they put it in the bill. So Bill 100, I believe it was. And I can't remember if that came when the emergency was declared, or if that was something they done right after it. I can't remember that. Or if that's before it that gave them the power to do it.
So I'm not familiar with Bill 100, but I am familiar with the regulation that it's 71/22 is the name of the Ontario regulation. And it's a very brief regulation. It's just 6 sections, but it very clearly gave the police power to seize driver's licenses. But in order to seize a driver's license, you have to actually walk up to a vehicle and ask the owner or operator for his or her driver's license, and they just didn't do that. And I taught municipal governance, and to get an injunction under section 440, it's the nuclear option. It's the big, so the fact that the city had to go and get an injunction showed that they weren't getting their own. I mean, the injunction would force their own employees and the police to enforce municipal bylaws. The idea is that the police were not enforcing municipal bylaws, at least they were not enforcing municipal bylaws prior to the provincial emergency.
And arguably, that was asked at my trial, right? That was asked at my trial. Brian's read it in my trial where they were asked, is there bylaws in place? Yes. And why were they not? Well, we weren't enforcing them. That's not an onus on us. That's an onus on law enforcement. That's an onus on the municipality. If they weren't enforcing the bylaws, how are you going to charge somebody with this bullshit? Like, this is a lot of things that people lost. Like, if this would have been televised, man, this whole country would have been changed by now. I know, just by watching the fiasco within the courtrooms.
But that's part of our argument, is that the police have an obligation under the Police Services Act to enforce municipal bylaws. It's not an option for them. The police don't have the option of saying we're not going to enforce bylaws. This is just, I don't know where the police got the idea that they could not enforce bylaws when it's their statutory duty under the Police Services Act for a municipal police force to enforce municipal bylaws. And then when the municipality gets an injunction under Section 440 of the Municipal Act, then the police have a double duty to enforce bylaws. And the police had the power to seize driver's licenses under that emergency regulation. So it was a temporary, it was a temporary emergency regulation. It was withdrawn. They withdrew it a few weeks later. But at the time, the police had all the powers that they needed for a civil resolution, a non-criminal resolution. And you would not need tow trucks because the police would order the owner or operator to drive away on the penalty of losing your driver's license. I'll seize your driver's license if you don't drive away, basically, is the power that they had, but they didn't use.
Which brings up Casaba.
Saba.
Remember what happened to him? They beat the shit out of him.
Yeah, they beat him with rifles and kneed him in the back and kicked him and stomped him. Yeah.
And then as far as asking trucks to leave, the municipality was blocking so many intersections with police cars, snow equipment, graders,
absolutely,
dump trucks. It was the municipality that was blocking the lanes. It was the municipality, and I seen this with my own eyes on many occasions. The cops.
Well, just to get a truck moved, it took 2 days to get a truck moved because you'd have to call your liaison officer. Liaison officer would have to call a city worker. City worker would have to sign a worker to the equipment to come in to move the Jersey barrier. And it took approximately 48 hours in order to get anybody off the roads. I just want to put one thing up quick. Ladies and gentlemen, if you care to, at the bottom of the page here, patkingappealfund@gmail.com. Everything's going to Brian. Brian is handling all of that, and it's in trust, and nothing goes towards me, just so everybody knows. I just want to put a shout out for that.
And we're going to publish, we're going to have available all information on how much was donated, and so everything is going to be accounted for.
Correct.
In the case of the two, I had some clients, and we had our trials in the Ontario Court of Justice, but we were at the corner. My clients were at the corner of Rideau and Sussex, and they were in their vehicles. And when the police came, they were forcibly removed from their vehicles. So I was able to make that argument. I mean, on that corner, they could easily have driven down Rideau Street and then taken a right at Waller or one of those streets, and they could have easily been out on the 417. And that was where they started. That's where the arrests started on February 18th. I mean, they were maybe started elsewhere, but they started at 12 noon on February 18th, 2022 at Rideau Street and Sussex. That's when they started removing people forcibly from their vehicles.
They got me at the War Museum.
Yeah. But that was, I think that was the time that the arrest started.
And when they did capture me, they said you weren't allowed in this red zone. If we all remember the infamous
the red zone. Well, this is the thing. The red zone is
I wasn't even in the red zone.
The red zone is a fiction. The red zone is something that the police believed that the Emergency Act provided for. This is what I was saying. This is why people, I think there were a lot of mistakes made that nobody wants to admit. But there was nothing in the Emergency Act that declared a red zone. There was no red zone in Ottawa. The only red zone in Ottawa was in the municipal injunction. And the only powers that police had within the red zone was to enforce municipal bylaws. So yeah, the red zone is I can say as a lawyer on my, the red zone there was no red zone unless you were talking about the red zone in the municipal injunction. There was no red zone whatsoever.
Yeah.
So I know you said about the Police Services Act that it's in there that they should have been enforcing the bylaws, and they never did.
That's their power. Their powers are established under the Police Services Act, and they were not.
But wasn't the so I'm not sure if they had repealed the Police Services Act. I believe, I don't know if it was repealed then.
It's been repealed, but there is a new Police Services Act, but it wasn't yet enforced. So the old act was still enforced. But even under the the old act, the new act, the police have an obligation to enforce municipal bylaws. A municipal police force has a statutory legislative obligation to enforce municipal bylaws. That's what the municipal police, that's one of their reasons for being a municipal police force in the first place, you know?
Yeah,
And it just
correct.
always astonishes me, when I read, reading everything, reading all the evidence in this case is that, the police just, they were marching around in public order units, and there's nothing in they can keep public order, but just marching around in public order units is not the same thing as, keeping public order. And you can't be picky and say, well, we're not going to enforce municipal bylaws. I mean, I just don't see how anyone, you police get their authority from statute. You can't just say, oh, we're not going to pay attention to the statute. We're not going to enforce bylaws. Perhaps they could have argued that we're not going to enforce bylaws because it's pointless, because giving tickets to people is pointless. But that's no longer true after February 12th. The police had all the powers that they asked for, all the powers they needed to enforce municipal bylaws. In fact, it should have been a model. It should have been a model of how to resolve a problem like the problem that Ottawa had in a way that doesn't require criminal remedies. But they went for the city went and the police went for the criminal remedies.
Correct.
So,
If quickly, Debbie, if you want to make a donation, shoot a friend of yours $100 that never had those conditions on their bank account. Nobody has to know.
What was I gonna say now, Ed? These powers that they had, and you were saying they never exercised them, I guess is what you're saying, and they just went straight for criminal instead of anything else. So can't there, at least on the sentencing for Pat, it's cripes. If it's only mischief they're going after and they're trying to bring intimidation back, to me, what I'm hearing, it kind of sounds like it's a collateral attack on the ruling, at least as far as the intimidation part goes. And the sentencing they're asking for, like I believe they just had a pedophile sentenced to 4 years, and that's a pedophile. We're talking mischief here, and they want 5 or 10 years that they were asking originally. Like, where's the cruel and unusual punishment there? Like this time does not fit the crime kind of thing of what they're trying to ask for.
Well, what we're arguing on the appeal is that Judge Hackland's sentence was sound, and it was within the range of what a sentencing judge can apply. 9 months plus 3 months conditional sentence, concurrent for all the convictions. So Pat was found guilty of counseling mischief,
which didn't occur. Mischief that didn't occur.
That's
that
right.
one blows my mind.
Well,
Explain
part of
that.
it is because mischief is a general intent offense. So they were able to argue, that's really how they got their convictions, because mischief is a general intent offense. But and the counseling, obstruct police, disobey court order. But the thing is, it like overturning a trial judge's ruling, you have to, in the case of overturning the not guilty finding for intimidation, you have to find an error in law. There was no error in law. The judge applied the law. Mm-hmm. Likewise, with a sentence, there has to be something that's manifestly unfit. The judge has to have made an error in law in applying the sentencing rules. But he didn't. He went over everything. He said Pat has had very difficult conditions when he was in custody for 9 months or 6 months, and you got credit for an extra 3 months, I think.
No, I was 5 months, total of 150 days, and then I was accredited for 9 months and given 3 months conditional sentence.
Right. Yes. So it was 9 months. You were given 9 months credit, but the trial judge, in his sentencing reasons, he went through He went through all the reasons. He went through the legislation, section 718, section 718.1, section 718.2, section 718.3. He didn't give the numbers, but he went through the reasoning, and he said, that he's already been in custody, time served, so we'll just add 3 months conditional sentence, and it was like house arrest, wasn't it, Pat?
It was, yeah. Yeah. With door
But
knocks. I hear other people are having problems with door knocks. But yeah, I had door knocks for 3 years.
So Pat,
but
what
so
surprises
I
me.
think the sentence will stand. Like, to overturn the sentence, they have to prove that the judge did not consider any of those statutory matters that they're supposed to consider, but he considered everything. He gave reasons why he was giving the sentence. I think the Crown has an uphill battle in overturning the sentence. I really do. And the case law is on our side. You really have to find an error, an error in law that was manifestly unfit. The sentence has to be manifestly unfit. There has to be something that the trial judge didn't consider. And again, like the way they argued the intimidation acquittal, the Crown in its arguments is mixing up error in law versus a disagreement with the judge's interpretation and application, interpretation of the facts and application of the law to the facts. But those are not the grounds on which you can overturn a not guilty finding. Those are not the
So
grounds that you can overturn a sentence.
can you not
Very, very high
agree
barrier.
that this is can you not agree though, Brian, that this is it's plain and simple, it's malicious prosecution? Can you say that?
I have to be careful what I say as a
I
lawyer,
know,
because
but
I
I
know
wanted to
people. I'm amazed. People have. I'm not really much. I don't say much in public, but I find that there seems to be a lot of awareness of things that I've said. So I think that by showing that there's no grounds to overturn the not guilty finding of intimidation, I think that sends a strong message. It's really the same evidence that convicted you on the mischief, and they're trying to use the same evidence to convict you on the intimidation charge. But again, because of this quirk of the Canadian Criminal Code, we've got mischief is a general intent offense, and intimidation is a specific intent offense. And really, that's, in my view, that's why so many protesters were convicted of mischief. But
everything else
intimidation, I
was
believe,
dropped.
that what was dropped?
Majority of everybody got mischief charges, and every other charges that they got hit with,
Yes.
they all got dropped.
Or they got finding of not guilty. I believe Tamara Leach and Chris Barber were found not guilty of intimidation as well. And again, I think it's because of this quirk of our Canadian Criminal Code, and this, we've got specific intent and general intent, and that's really the difference. But I think it's a key difference. So I think by if we can win this appeal by just having the Crown's arguments rejected, I think that says a lot. I don't think we need to do we could, if you went through and did a cross appeal of the mischief, again, it's when you're trying to overturn something that the trial judge found, you really have your work cut out for you on appeal. I think
Correct.
This way, by we're merely responding to the Crown's appeal. And I know I've been involved, that's what I was asked to do. I think we can send a very strong message if we win, if the Crown's appeal fails, because we're still arguing the same argument that you didn't do anything wrong.
Of course,
you were just protesting. And we also argue the Charter of Rights, Section 7. So that's the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. So Section 7 works in our favor because Section 7 means that they can't argue that there's a specific intent here because it violates your charter rights to have freedom of expression. And so it's a combination of the charter, combined with the issue of specific intent, the lack of specific intent beyond a reasonable doubt. I think that's, I think that's why we have some very strong arguments. So I think if the Crown's appeal fails, I think that will say a lot. I think.
Stefanos,
I don't think we need to do like the cross appeals and things. I mean,
Stefanos, what was that court case where we met down in Niagara? That gentleman was also charged with mischief, was it not?
Which one are you referring to?
Where there's a whole courtroom erupted when the judge said dismissed on all counts.
That was Cullen McDonald.
Colin McDonald.
Was that mischief or not?
That was the COVID. That was his.
That was the COVID stuff.
That was the COVID stuff. He was a doctor, if I'm not mistaken.
I don't know if he was a doctor. I think he's just an ordinary Joe. They were trying to go on they tried to argue the Alberta stuff, that they nailed the Powalski on, and they tried to bring it against Donald, and the judge had none of it. I knew it was done right away because the prosecutor was nervous. His voice was crackling. He knew he was.
He was charged with 3 counts of common nuisance, who dared to protest public health mandates. 2 charges for attending a protest in Niagara, and a 3rd for attending a protest in St. Catharines.
Yeah,
charges in Niagara were acquitted by Justice Richard Bluin, who concluded that elevating a violation of provincial health orders to criminal offense would set a dangerous precedent.
Yeah, and they tried to argue that. Then they tried to bring in the doctor's evidence that the government had and everything. But the judge, he knew it was all BS, and he made his ruling and ran. Like literally. Okay, so as a lawyer, Brian, you know that judges can say things during a trial while it's going on, and they let each side know how their case is going. But the beauty of this was I already knew it was done, because when the prosecutor was trying to make his argument, the judge literally turned his seat sideways. He wasn't even looking at him, and he wasn't having none of it. And right away he said, "You don't have to make any submissions. You don't have to nothing." And boom, it was denied. Out he goes. So Cullen won, and the judge got up and literally ran out of the courtroom. It was pretty funny, comical.
That's funny.
So
all right. Well, we're coming up to 1:11. I got kids that got to go to bed here, guys. I don't know why you guys do this so late, but
we're not.
We have to be across Canada, so it's in British Columbia. It's still supper time.
This
or
is
just
true.
after supper time.
Correct. But Brian is doing an amazing job, ladies and gentlemen. So if you all do know, if you care to, it's on the bottom there, PatKingAppealFund@gmail.com. And yes, all donations are in a trust. Brian has all control over it. Nothing goes into my pocket, just so everybody knows. I know a whole stipulation.
Everything will be. So anything that is anything that I take, or anything that I put from my trust account into my operations account, it has to be accounted for in my invoice. So I will send. So anything that I put in my own bank account out of my trust account would be has to be accounted for in the invoice. So everything, all the money is accounted for, and anyone who wants an accounting can ask me, and I'll provide it.
Pat, you kept bringing up many times tonight that they convicted you on intimidation that was never happened.
No, mischief that did not occur, and counseling to mischief that did not occur.
Brian, can you address this quickly?
Well, these were the mischief and the counseling mischief are not under appeal. So I can agree I guess I'll go back into the refuge of specific intent versus general intent. And I think the reason why the Crown, like I said, I think there were a lot of mistakes made. If you look at like the early criminal informations, like when they charged people, and I don't know, Pat, I think they recharged, they relayed the charges several times with you. That was a common thread, was the relaying of charges. So I had my clients had their charges relayed three and four times. But my point here is that in the initial information, and this is true for David Rumlowski, who the late David Rumlowski, who I represented in his application for leave to appeal to the Supreme Court. The first information had as a charge section 127.1, and that's the section of the criminal code that says any order, any court order, or any order of any authority for which there's no clear punishment. And so it's kind of this go-to charge under the criminal code, section 127. But they were talking about section 127 and erroneously attributing, referring to the federal, or I'm sorry, referring to the provincial emergency regulation as a reason giving the police grounds to arrest. But there was a mistake, because that's not what the regulation said. The regulation dealt with police powers to arrest. I think there were a lot of problems made at the time of the arrest, and then ultimately, after about 3 or 4 months, by about May, the Crown kind of settled on this idea that they were going to charge everyone with mischief, and a lot of these charges under section 127 were dropped. I think they kept one up on you, Pat, for the Lexi Lee, the horn honking.
Yeah.
But a lot of the other section 127 ones were dropped for a lot of protesters, and they just focused on mischief. And I think one of the reasons the Crown focused on mischief as the go-to charge was that mischief is the general intent offense. So if they just prove that you were participating in the protests and that there was an impact on the people in the community from the protests, then they could convict for mischief. I'll just say one thing. For my clients, I refused, I contested, I never signed an agreed statement of facts. The Crown wanted me to sign an agreed statement of facts. The Crown wanted me to agree to a statement of judicial notice that there was an occupation of Ottawa. But I fought that tooth and nail all the way. So I had two clients. They're both removed by force by tactical officers from their vehicles at that intersection. But I was able to argue that there was no mischief, because like the mischief has to be under the criminal code. The mischief has to be like blocking someone's egress or access, blocking an entrance to the road, or blocking an access from the road, blocking access to a business, blocking access to an office. And I think, if I understand you correctly, Pat, you were saying you weren't blocking anyone directly. There was no mischief in the sense that you weren't blocking anyone's
I didn't even have a vehicle.
And you weren't even in a vehicle.
Didn't even have a vehicle.
What
you
bugs
didn't have
me
a vehicle
most,
when you were arrested.
So
I guess
I never had a vehicle the whole time. I was a passenger in the motorhome driving there. The motorhome was parked in an undisclosed location. Every time I was in Ottawa, I was on foot. That's the other part that this whole fiasco is. I'm being charged with mischief and horn honking and the injunctions. I never even had a horn to honk.
I know, but they were
This
also
whole thing
able
is
to
just
use section
absurd.
21, and this is the other thing that a lot of people don't realize what the Crown did. They used section 21 of the criminal code, and this is a section that goes back to the common law, which says everyone is a party to an offense who actually commits it, does or omits to do anything for the purpose of aiding any person to commit it, or abets any person in committing it. And that's what they did with David Rumlowski. That's what they did with uh, Guy Meister, they use Section 21 to say, okay, if you were participating in the protest, then by virtue of Section 21, you were participating in the mischief. And then on top of that, they use judicial notice. So in one of my clients' cases, so we said, well, there was no mischief. The police didn't have reasonable grounds that he was committing mischief because he was removed by a tactical officer by force from his vehicle. They said, well, nevertheless, they took judicial notice. The judge took judicial notice that there was a larger, wider mischief in Ottawa, and by virtue of Section 21, convicted my client of the mischief charge. So again, I will have to read the reasons for decision again, but I believe Section 21 is used in your case as well, Pat.
Pat, you probably
So
could
that's
agree with me on this statement if I could. I was there because it was a lawful, peaceful protest. I had no
100%.
criminal intent, correct?
Correct.
So where's the
Everybody
mens
knows
rea?
that. Everybody
Where's the
knows
mens
that.
rea?
But I guess that's the difference between the that's why I think it was easier for the Crown to get convictions on mischief, because all they had to do was prove that there was a mischief. Again, so you had judges taking judicial notice that there was a mischief, and the judicial notice is based on the Crown's arguments. So the Crown made presentations, they made motions, applications to the court, asking the judge to take judicial notice that there was a wider occupation and that this constituted the mischief. And that's how they did it. So it's a combination of Section 21 plus the judges taking judicial notice of the wider mischief. So then the argument goes, so all they have to do is prove that you were actively participating in this protest, and by virtue of Section 21, they found the conviction on that. But getting a conviction on the intimidation is a different kettle of fish because of that, those words, for the purpose of compelling, and when criminal legislation contains words for the purpose of, that makes it a specific intent offense. And I think that's why they chose mischief as their go-to. I think mischief was, I think, beyond a doubt the offense that I think every single protester who was prosecuted was charged with mischief.
Yeah.
And I think that is at least mischief. Mischief was the go-to charge.
But the criminal mind, the criminal intent, there was millions of people in Ottawa. I don't think there was even one person, with the exception of Zex Lee, that has a criminal intent or a criminal mind.
Well, again, it's because of the way the Section 430, the mischief offense, the way it's written. So again, and I'm just saying this is how it happened. Again, for my clients and their trials in the Ontario Court of Justice, I fought tooth and nail to keep this against these arguments in Section 21, against the judicial notice of a wider mischief. I fought tooth and nail, and I said, look, if you have a tactical officer forcibly removing someone from a vehicle, that tactical officer doesn't have any reasonable grounds to believe that the person was committing mischief. But again, and what the Crown did in my cases and my clients' cases and in many other cases that I observed personally, is that the Crown would use this approach, and they would get a conviction. But the thing was, even the lawyers were taken by surprise that Section 21 was being used, and it was sometimes only later in the trial, and the Crown was relying on social media evidence, and they weren't really straightforward about that. You didn't realize that they were relying on social media evidence until you actually got in the trial. You realize that the only evidence that they were calling were other police officers.
Yeah, so news articles, stuff like that is hearsay. It's inadmissible. They can try to put it in. You can object to it, but wouldn't the social media also be the same thing, unless they were using Pat's lives or whatever? But if it's comments on social media from other people and stuff, Like, I don't know, I wasn't there, so I don't know what
Well,
they actually use, but
well, I think in Pat's case, his trial lawyer agreed on an agreed statement of facts to accept the social media evidence as evidence in the trial. I'm not going to criticize any other lawyer's approach, but my approach was I would not sign any agreed statement of facts with the Crown.
no,
I would not admit anything. I mean, it's up to the Crown to prove that there was a mischief. So, in the case of Guy Meister's case, at the end of the day, the judge convicted on the basis of the judge taking judicial notice of the wider mischief plus section 21 of the criminal code, and that's how they convicted Meister. But then on Meister we got a discharge because there's a different set of rules on so arguments that didn't work to get a not guilty on mischief, you can still use those arguments again on when you're arguing for the sentence. So in Guy Meister's case, we got a discharge, conditional discharge, which I think is
Correct.
one of the only, if not the only discharges for any convoy protester that I'm aware of. But again, it's so a lot of these arguments that the Crown or that the judge maybe wasn't willing to accept, on the sentencing, they go to your moral blameworthiness, and I would argue that Pat is less moral blameworthy. There's less moral blameworthiness. I know that's a mouthful, but that's a sentencing term. Moral blameworthiness. So there was.
all right. Well, I think, anyways, we've gone way over our limit. Pat's gotta go. He's got. I just want to say, Pat, thank you for coming on. Brian, thank you for coming on. And
Thank you.
Pat, I really got to commend you at the inquiry when you were on there. You were the best ever. And when you made that lawyer freak out, I actually cracked a beer. It was so enjoyable. You'd done the best out of everyone at that inquiry. Thanks. It was great, great stuff.
Well, I appreciate it.
Thank you. Thank you for
And
having us.
we'll be doing more of this with Brian as well. We'll be doing a few more podcasts with everybody else. But Brian, thanks for coming on and explaining it to everybody. Brian, before we go, you happen to have just a ballpark of how much we've raised so far to give the audience?
We've raised about $4,500, $4,500 around about.
Oof, we got some work to do, huh?
Yeah, but I'm happy to be doing this. And
I'm happy. You're
happy.
happy.
I think it's an historic case. I think this whole series of cases I think are historic, and I think we want to put our arguments on the record. And even if the judge doesn't agree, I think by putting these arguments on the record, people in the future will look back and say, hey, why were they focused only on Lexi Lee's injunction and not on the municipal injunction, when they're two very different injunctions. So thank you. And I apologize for the technical difficulties I'm having. For some reason, I wasn't able to get my my phone, my computer working. So I'm on the phone now. But yeah, I'm happy to have participated. I'd be pleased to participate again if in the future. And we're working on the so we've got 60 days from the day that the appellant application is filed. So we have about 3 more weeks or so. The arguments are ready, but we just still have to write the beginning, the first 10 or 15 paragraphs.
Correct, yeah.
And but we're almost finished. And then I think with Pat, I'll put it on my Twitter and people can read it there.
Absolutely.
Yeah.
Again, it's great to have you guys on. You know what? I thought I knew what was going on with your case. Now it's clear as mud. Man, oh man.
I think we're in a good position. I finished the argument. I like to write the argument and then write the facts. And I think we've got good arguments. I really do.
I wasn't kidding, Ed. It's a nightmare, bro.
Yeah.
It's a witch hunt.
Well, I think for history, we're going to put our best foot forward here and say, hey, there's no moral blameworthiness here for Pat King. He's not
Correct.
morally blameworthy for this.
Well,
He's
you're as guilty as the millions of other Canadians that showed up there.
Well, you'd think right now the hashtag should be hashtag I am Pat King. For everybody that was there, hashtag I am Pat King.
Because everybody was there, came there with the understanding to do a peaceful protest. There was major problems with our government, what they were doing to us. And people had enough, and they knew what they were doing. The government was doing to us was wrong. And that's why a lot of these these illegal acts that they did went away after a few months. That's why our country was one of the last to open up.
Absolutely.
And I commend every Canadian for showing up to that. And I appreciate each and every one of the Canadians that did show up. And
I think history will recognize. I think the freedom convoy protests played a significant role in getting things to change.
Agreed. All right, gentlemen, I am signing out, and we'll talk soon. Thanks for having us.
Thank you.
Thank you for coming on. Thank you.
Thank you very much.
Thank you.
Oh, thanks. I'll sign off. Thanks,
Till
guys.
next time.
Till next time. Thank you.
What do you think? I am walking mischief.
That's. I have better ones, but I'm not even going to say anything. All right.
Guys, thanks for tuning in. Spread this far and wide. More people need to know what they're doing at Pat King and the hell they're putting them through. We never ask for donations, but some of our guests really do need the money. And if you can, donate to his appeal, because I don't know if he started working again, but he's been out of work for a long time. And he's having a hard time finding jobs because he is such a high, very noticeable person.
High profile, Ed. High profile for sure.
Yeah. So he did not want to appeal. He didn't have the money. I think his accounts are still frozen, so he can't even use his own money. And he's relying on us to, help him out. If you can send even $5. If we got 200 people sending $5, it's a couple grand right there, right? So this is not just for him. This is for all of us. Keep that in mind. And if you can make a donation, great. These lawyers do cost a lot of money. Anyways, welcome. Thanks for tuning into the lounge every Thursday night, 9 p.m. We deal with constitutional and other legal issues on a weekly basis, stuff you'll never hear or read about in the newspapers or mainstream media. We go after the stuff that's not getting covered. We bring the important stuff to the forefront. And see you guys next Thursday. And don't forget to donate. Pat King, appealfund@gmail.com. Stefanos, final comment.
No final comments. It's good. It's good. Just help the guy out. He needs it. He's going through all of this for every single one of a Canadian in Canada. He's gone through all of this for everyone. It's not no self, glorifying thing or anything. He's taken the beating. He's taken the punishment, and he's still taking it years later. Help him out, because he helped every one of you in Canada out. Whether you're on one side or the other, like it or not, he helped you out.
And you think of all the investigative reports Pat King's done over the years, all the personal time that he's donated to the country, trying to educate people on what's really going on behind the scenes. This stuff you never hear the CBC report about, but they should, had they been a real newsworthy. But they're not. It's propaganda. They only feed you what they want you to hear. They're trying to brainwash us through mainstream media. That's why the public media is all paid for by the government. We're here, guys. This is communism. We're right on the cusp of it. Important case. Donate if you can. And I'll leave you guys with that. Later.